if you have any questions as we go through this, definitely just drop them in the Q&A. Gonna hold some time at the end to review those and go through them. So yeah, I am here for you. Throw them in there. Cool. As mentioned, our topic today is embracing data privacy in digital marketing. Who I am, again, as mentioned, I'm the head of global privacy strategy at Infotrust. So I help organizations all across the globe kind of at that intersection of compliance, technology, and business outcomes. Quick legal disclaimer, I always have to throw in here. We'll talk about some of the various different laws and regulations in the US that are going to be applicable and talk through some of the kind of the foundational strategies. But as always, it's just educational content. Always seek legal counsel when making kind of some of those final decisions. As for the actual content and what we will be walking through. So my goal is when we walk away today that everyone will have a good understanding of the current state. So what is kind of the current state in marketing? What is it that consumers expect from us? Key privacy considerations to keep in mind. As mentioned, we'll go through some of the different regulations, but I want to just make us all aware of the critical foundational requirements so that they're always in the back of our mind. And then walk through how is it that we can actually approach those questions and gather that information, again, as marketers to be effective, but also to not have to be the privacy office. We'll wrap up with some core key takeaways, and also I'll go through a little bit of an exercise for how you can map out some of those different compliance requirements related to common activities. And then at the end, happy to answer any questions that anyone has. So in terms of the current state, we are at a bit of an inflection point where consumers expect personalization. In a Google and Ipsos study, 91% of internet users said that they are more likely to shop with brands that provide offers and recommendations that are relevant to them. To me, that says that they expect personalization, and this extends into the advertising and marketing environment. Interestingly, I'm putting together a kind of like a privacy digest newsletter for our clients, and I sent out to a handful of folks for some feedback on the content. And these are all compliance professionals, people in the privacy office at organizations. And the number one piece of feedback was, I would love for this to be a little bit more personalized with specific articles and things relevant for me. So even for people that are very privacy conscious, that is what that expectation is. Now, at the same time, we have a situation where individuals are more likely than ever to be skeptical about what information is being collected, how it's being used. They're more likely than ever to be taking actions to block the collection of the data that's necessary for that level of personalization. And we see that through opt-outs, we see that through ad blocker usage, we see that through people not opting in for things like Apple's ATT. So we're left with this kind of core problem as marketers. How do we accomplish our core business use cases, and how can we still be effective, but do so in a way that is privacy-centric and respects those requirements and those expectations of consumers? How we approach this and how it's really structured in the book is to focus on three different pillars of privacy-centric marketing. Those three things are, number one, first and foremost, always respect the privacy of consumers. Number two, really try to take control of the data, the pipes, how things are distributed, and assert first-party ownership of first-party data. And then number three, rely on and make decisions based upon insights and an understanding, as opposed to relying on technology and kind of that one-to-one deterministic type of matching that has been there in the past. Today, we'll be focusing on that first pillar, which I think is, to me, the most critical, respecting the privacy rights of individuals. Now, when we talk about respecting the privacy rights of individuals, kind of luckily, but at the same time, unluckily, we have really good frameworks and blueprints to work from. We have a really good understanding of exactly what those guardrails are and what our requirements are because of the various different regulations, laws, and requirements that are out there. In the United States, how it really breaks down is a few different core areas. The first one are comprehensive state privacy laws, which Tennessee has a new law that will go into effect just this year. We also have individual state laws that really govern and are focused on specific activities. We'll cover some of those. There are some federal laws. Unfortunately, in the US, there is not a comprehensive privacy law that can really make everything uniform and easy from an operational standpoint in the US, but there are some federal laws that have impacts on marketing activities that we can do and lean into different considerations. And then I know a number of folks in this audience are in the healthcare industry. So also kind of point out some of the different requirements and things to keep in mind as it relates to healthcare specific laws that are out there. So we're not going to dive into the nuance of all of those. Each realistically is its own session, if not more. But again, want to focus on kind of the basics and the foundational elements. And where we'll start here, because it provides a wonderful starting point and kind of initial foundation, are the US state privacy laws. So as of today, there are 13 states that have fully passed comprehensive privacy laws in the US. 5 of them, California, Virginia, Colorado, Connecticut, and Utah, are in effect as of today. In 2024, we have 4 additional states, Tennessee, Oregon, Texas, and Montana, with laws that will go into effect. And then in 2025, and Indiana's way out there in 2026, 3 additional states. Just on Monday, also, New Jersey, their legislature passed a bill, and it is sitting on the governor's desk. He has 45 days to sign that into law. All expectations are that he will. So that will, again, just add another state to the list. That would go into effect in 2025 if and when it is signed into effect. So there's this growing tide across the US of states that are implementing privacy laws. Unfortunately, it's in a patchwork manner. So again, it's not totally uniform everywhere. That said, a lot of those different laws really follow 2 different models. California, who was the first, kind of the most comprehensive, and then everybody else that follows their own model, which is kind of modeled after Virginia was the initial one that was passed, at least, that is modeled after. And so we can take components of all of those and we can condense them down into, again, just those core things that marketers need to be aware of. All the examples, like the explicit examples that I'll provide in here, are directly from the Tennessee state privacy law, which again becomes effective in July. It should be applicable for most of you, I believe. So on that question of applicability, there is this kind of concept in the US. There are minimum thresholds that need to be met before these laws become applicable. In Tennessee, those 2 are listed there. Essentially, there's a threshold above which, for the number of users for which that you're processing their personal information, as well as if you are selling, then that threshold's dropped a little bit. Tennessee is kind of unique in that there's not a dollar amount threshold. In California, Virginia, many others, there is a revenue amount threshold that needs to be met. But once these thresholds are met, then any business is obliged to follow those various different requirements. It is also important to note here, there are some common exceptions in all of those laws. So we mentioned healthcare. If you're a HIPAA covered entity, then HIPAA reigns supreme there. Similar nonprofit organizations are exempt from these laws. A lot of financial institutions that have other regulations that apply to them. Now, sometimes I get the feedback from folks that, oh, we're small, these things don't apply to us. And I counter with kind of 2 points. First one being, well, I think you probably hope that you're going to grow. So maybe in the future, you will hit those thresholds. And so you need these foundational kind of components in place. But also, we need to keep in mind consumer expectations. Laws, regulations don't happen unless there is constituent support, basically, in order for those initiatives to be worked on and passed. So a few statistics here to ponder regarding those consumer expectations. Adobe did a survey where 66% of consumers said that they would stop buying from companies that misuse their data. Google has done a good amount of research. Some 81% of people said that they would prefer to buy from brands that are honest about what data they collect and why. And most importantly, and one of the things that I really highlight a lot, 49% of folks in a Google study in the Americas, it was higher in Europe, but in the Americas, said that they would choose to switch from their preferred brands to their second choice brands if they were offered a superior privacy experience with that second choice brand. So following or kind of considering and putting privacy at the forefront and respecting the privacy of consumers is not just that legal requirement. It's not something that sits in just with the compliance team. It needs to be considered and really taken into account with marketing, throughout the entire organization. So we talked about applicability and why everyone should care about this. So what is it that we're kind of required to care about? So all privacy laws are focused primarily on personal information. And that's what people have rights with respect to, and that's where the various different obligations really come in. So personal information is information that identifies, relates to, or describes a consumer and is capable of being directly or indirectly associated with a particular consumer. A few examples here, just to kind of bring this home. Obviously, clear text identifiers, real name, email address, the things that we traditionally think of as PII, or personally identifiable information, those things always going to be in scope. But also things that, again, relate to a specific individual. So things like device identifiers, cookie IDs, as well as any information that can be associated with those different device identifiers, cookie IDs, user IDs that you might be collecting as a part of digital advertising. And the behaviors that can be associated there. So it's quite wide. Any of those identifiers associable with an individual are going to be in scope. So this type of data is used across many, many, many different marketing activities. So a few examples here: digital advertising, for doing any kind of targeted advertising, that's going to have personal information. Email marketing, personal information. Web analytics, because we're dealing with client IDs or device IDs in order to be able to stitch actions together, personal information, as well as any kind of experience personalization that we're doing on the website. If we have personalized recommendations, if we're personalizing content based upon past behavior, all of that requires personal information kind of under the hood in order to operate. So in all of those cases, we're going to want to at least take some considerations here in order to be able to make sure the proper protections and requirements are being met. So for those requirements, there's kind of two buckets that we can generalize here. The first one are requirements as it relates to consumer rights. So all of us as consumers of businesses have these rights afforded to us by these various different privacy regulations. And therefore, as organizations and marketers, we need to be able to respect these rights. So if we break them down kind of in these four categories, the first right that is universal everywhere is always related to transparency and disclosure. Disclosing exactly what information is being collected, whom is it disclosed, where are we sending it, what partners are we working with, how and why is it being used, and then what that impact is to the consumer always needs to be available to the consumer for them to be able to understand. There's always going to be, as mentioned, some nuance for exactly like how this needs to be disclosed. And that's going to be regulation specific. That's something that you'd work with the privacy folks in order to be able to make sure it's in the proper format. But the principle is kind of foundational there. Second consumer right is access. So if someone asks for their personal information that you've collected about them, you need to be able to provide it to them. Third one is correcting inaccuracies. So if you have inaccurate information about an individual, they have the right to make you correct it. It's easiest, obviously, if we're always trying to at least collect accurate information up front. Consumers have the right to delete their personal information. So you need to be able to delete any of that information that you have collected about a consumer. And then consumers also have the right to opt out of the sale of personal information, which there's some nuance to that definition of sale, but generally think of really any kind of digital advertising activity, any like targeted advertising activity, is probably going to fall within that definition. Now, in Tennessee, that opt-out right ends at sale. In most other states, there is also this provision that expands that opt-out ability also to the sharing of personal information for specific use cases. One such use case is for targeted advertising. So any kind of like remarketing that you're doing, or if you're creating audiences based upon behaviors, or you're personalizing advertising based upon observed behaviors on your digital properties, that's going to fall within that targeted advertising definition. Consumers have the right to opt out of you including their information or using their information for that purpose. A note though on sharing, there are also exclusions for that. One of which is for like first party measurement. So analytics use cases, measuring the effectiveness of your campaigns, measuring conversions, those types of activities are not in that definition. So first party analytics, you're okay, but know that for a lot of those other marketing activities, consumers do have that right to opt out. In addition to controller rights, there are also kind of defined requirements for controllers or for the organizations that are responsible for the collection and determining the use of information that's being collected. So if it's your organization's website, you're going to be the controller. The obligations for those controllers kind of break out in these categories. The first one is data minimization, which is the principle that we should only collect that which is absolutely necessary to accomplish the defined use case. Anything else, we should not be collecting. Now, that's been a best practice for quite some time. Only collect that which you're going to use. Don't collect extra information. But now it is a regulatory requirement as well. So data minimization is super important to think about whenever we're thinking about data collection strategy for any kind of activity that's being done for marketing. Second requirement is that controllers need to have technical and operational protections in place to be able to make sure that personal information is not disclosed improperly, there is improper access, no breaches, things like that. We also have the requirement to not unlawfully discriminate against consumers. And the big one here in the context of these privacy regulations is that we cannot discriminate based upon an individual's desire to exercise their privacy rights. So just because someone opts out of the sale or the sharing of their personal information does not mean that we can, deliver them a subpar or a substandard or a different experience. The fourth principle is to only process sensitive data with consent. We'll talk about this a little bit more in the context of some of the health data that could be out there, but there are additional care that is required for what is called sensitive data. That transparency and disclosure, that again is an obligation for the controller. And then Tennessee is one of a few states that also includes this requirement for data protection assessments. So a note kind of on those data protection assessments, and specifically again to Tennessee. You are compelled to conduct a data protection assessment for any processing activities with personal information for a defined set of different activities or different things that you would be using that data for. So if you're using that information for targeted advertising, if that information is involved in that sale definition, if that information is being involved in profiling, which you can also kind of think of as just segmentation, if there is a foreseeable risk of negative impacts, injury to the consumer. A DPA is required for processing of sensitive data. So again, we'll talk about a little bit more in the context of some of that health information. And then really just any activities that present a heightened risk of harm. Any of those activities, if we're doing any of those things with personal information, then there's some core obligations here to identify and weigh risks versus benefits. Make sure that any safeguards that are potentially available in order to be able to mitigate those risks are in place. And then to also factor in some of those other methods. Could we use de-identified data? Could we identify this information? So again, what protections could be in place? We have to do that balance test. We have to be able to justify that, yes, the benefits outweigh the risks, and then document that what exactly those risk mitigation strategies are. So a couple notes here for the requirements. These DPAs, they're not publicly available. You don't have to publish them to the public, but upon request from an investigator with the state, they would need to be provided. So it's always important, again, think about just in the context of marketing, it's mostly going to be in that targeted advertising area. But if we're doing targeted advertising, again, things like remarketing, things like creating audience lists or targeting based upon behaviors on our website, we want to make sure that a DPA has been conducted and is documented for that behavior. In addition to those state privacy laws, kind of layered on top, we have various different federal laws. So at the US level, most of these are a little bit more kind of use case specific. So we have HIPAA, which applies to health information for HIPAA covered entities. We'll talk about that a little bit more here in a moment. We have COPPA, Children's Online Privacy Protection Act. So if you're dealing with any children's information, there are additional requirements there. A really interesting one that's cropped up in the last about year and a half is the Video Privacy Protection Act, which was kind of interesting story for where that came from. It was passed in the early 90s when a nominee for a Supreme Court justice, he was from, I believe, Washington, and a local news reporter went to his local like Blockbuster Hollywood video store and got a printout of all of the videos that he had rented in the prior year and then published that in the paper. So Congress was quite concerned at the time that any journalist could go to, you know, the neighborhood video rental store and see all the things that they were checking out and their interests. And so they quickly passed the Video Privacy Protection Act for that initial purpose. Within that law, there is a private right of action. So what that means is that, you know, attorneys anywhere can file suit against organizations for violations. Well, it's very unclear in trying to apply that to digital data. So we've seen a large kind of uptick over the last year and a half of various different attorneys mass filing these complaints under the VPPA for organizations. And all those complaints relate to video tracking. So if you're doing video tracking on your website and doing that video tracking with something like a Facebook pixel, which then informs, you know, advertising within the Facebook platform, that's where we were, you know, seeing these VPPA risks. So I always call that one out. One, interesting backstory, but two, it's kind of an unknown for some of these like older laws and then being applied to kind of current activities. And it can present, if nothing else, a compliance headache, simply because no one's actually been hit with a full violation on this point. Some organizations have settled, other organizations have, you know, won motions for dismissal, but in the end, it's still operational overhead. It's still working with attorneys to put together a legal strategy. It's still having to build that defense, which can be costly as well as can, you know, distract from regular day-to-day activities. In addition to VPPA, the FTC Act. So in lieu of a federal kind of comprehensive privacy regulation, in the last year, we started to see the FTC step in and use some of their kind of powers. Specifically, Rule 5 of the FTC Act, which deals with unlawful and deceptive business practices. And they've been kind of litigating or filing suit against organizations under that clause for even things like inaccurate disclosures. So if you're doing some type of an activity using information, disclosing it to various different third parties, often in that targeted advertising context, but it's not being disclosed to the consumer, that's where we're seeing some of those cases. There are also, similar to BPPA, there's some wiretapping laws out there. So if you're using like chatbot functionality on websites, and if you're recording those interactions or using those interactions for some secondary use cases, some of those can kind of come into play. Most have been under CIPA, which is a California law, which again carries that private right of action, but something to be aware of for if you're have anything with like keystroke data, chat type information as well can present a little bit of a risk. So on top of those broader federal laws, we also have various different regulations that are really focused on specific industries or specific types of data or information. One of the big ones is HIPAA. So HIPAA applies to HIPAA covered entities, which if you're a covered entity, you should know you're a covered entity. Healthcare groups, hospitals, people that are providing health care, as well as it's escaping me, providers, basically. HIPAA covered entities are governed by these HIPAA requirements. And HIPAA focuses on personal health information or individually identifiable health information. The definition there is any information that relates to a health condition, provision of healthcare, or payment for the provision of healthcare, and either identifies the individual directly. So it's like an email, name, address, that type of information, or if there's a reasonable basis to believe that it could be used to identify an individual. The scope here for enforcement was changed about a year ago with an OCR bulletin that was focusing on tracking data. So data collected via marketing tags and pixels that are running on websites. So if you're using something like Google Analytics, there's a tracking pixel. If you're using Facebook, they have a tracking pixel. And that has kind of broadened the scope of what is being considered PHI and the protections there for many organizations. Now, again, we could talk about that for hours. There is some additional content that we put out there. I've done a few webinars, written a lot of things for like specifics on that on the Infotrust website. So check those out. But kind of broadly know that those are the things that are in scope. There are restrictions on how that information can be used. Again, in the marketing context, really focused on that targeted advertising, as well as restrictions on disclosure. So who is it that you can send it to? Those complications related to marketing around disclosure is mostly that any third party that data is being exposed to or disclosed to needs to have a business associates agreement signed with the covered entity. And what we're seeing is that there's a lot of organizations, marketing technologies that won't do so. And that's where restrictions are starting to be kind of placed, and organizations are struggling to use even something like a Google Analytics for analytics tracking on their websites. There are some kind of architectural things that can be done there to limit some of those risks. But ultimately, it's always a risk calculation between business value, compliance risk that's determined with the discussion in the privacy office for even if those mitigation strategies are enough. In addition to HIPAA, so as mentioned, HIPAA is very targeted and focused for applicability to those covered entities. What we're starting to see over the last year, 2 years, is more regulators that are identifying gaps. So if we're not a HIPAA covered entity, but we're still dealing with health related information, how are consumers being protected in that case? And so that's where we're starting to see some healthcare specific laws or health data specific laws as well as some provisions in the state privacy laws that kind of broaden the scope and would also apply to health data. So the first thing to note here is US state privacy laws. I mentioned before some of those additional protections for sensitive data, and the requirement in many of these which requires affirmative consent prior to collection and processing of sensitive data. Well, in borrowing that definition from the Tennessee law, included in that definition for sensitive data is any personal information which would reveal a mental or physical health diagnosis. So this requirement applies to anyone that's applicable for that Tennessee law outside of even those covered entities. So worked in the past with a number of pharmaceutical companies, for example, and that's where some of this risk can be introduced. What the requirements are as relates to sensitive data, again, those data protection or privacy assessments to be able to weigh that benefit and the risk, make sure that risk mitigation practices are in place. So we have a higher standard of care for that information. It also requires some unique disclosures within a privacy notice as to what sensitive data may be collected, where it's going, how it's being used, all of that. And then it also requires that affirmative consent. Affirmative consent requirement is true for all the state laws except, interestingly enough, California, which does still have opt-out, but it is unique to that sensitive data. We're also starting to see more health-specific laws, again, at the state level. So towards the latter part of last year, Washington passed what's called the My Health, My Data law. And that requires consent or necessity to collect and use any kind of consumer health data. And that is defined as any data that identifies a consumer seeking healthcare services, that even being within scope. So this is one of those areas where, again, it's broadening that scope even for HIPAA. I know a lot of folks in healthcare, it's like, okay, sure, we'll remove tags or limit data collection on scheduling pages, anything specific to a particular ailment or anything specific to someone looking for a particular hospital or a particular location, but still doing some tracking and building audiences from people that just generally enter the website where there is no information or there is limited risk of any kind of a specific ailment being disclosed. This broadens that scope to even include those types of activities. Again, doesn't mean you can't do it, just means that it requires certain types of disclosure and affirmative consent prior to that information being able to be collected. We also have the health breach notification rule, which, if in scope, there are requirements for any kind of authorization to disclose health-related information. Typically, we see this as kind of an add-on. There were a couple of FTC settlements last year where the health breach notification rule was kind of cited as an additional breach or additional violation in addition to things like the FTC Act, in addition to things like HIPAA violations. And then speaking of the FTC Act, again, we're starting to see the FTC being much more willing to litigate privacy misrepresentations as deceptive practices. And again, that usually relates to not disclosing certain activities that you are doing or making a misrepresentation about how you're using data that is not in line with what's actually going on. So example would be, yep, we're collecting information for our own analytics purposes, but if you're also using that for targeted advertising and not properly disclosing that. So talked about all the fun requirements. Now, what is the downside here for penalties? So first, we have financial penalties. In the Tennessee state law, you can be fined up to $15,000 for each violation. It's important here, each violation is any provision that is broken, as well as the violation for each consumer that is affected. So that number can get really high really fast. If, for example, you have breached the we're not respecting opt-out, and we've had 50% of our users that are opting out, and we have 100,000. Now it's 50,000 times that 15,000 is our max kind of civil penalty there. There are also, not included in Tennessee, not included in the state laws, but I mentioned before some of those private rights of action for things like the VPPA, for things like some of those wiretapping laws. That can be, yeah, an annoyance, even if we're not losing those various different cases. In addition, there's this concept of relief. So courts can order organizations to stop doing a particular activity, as well as impose more stringent requirements for reporting, for documentation, things like that, which can add significant overhead for the compliance department, which then cascades down to marketing. So these types of things can really be impactful. A couple of examples here: in an FTC settlement last year against BetterHelp, which their provision like virtual health information, or virtual healthcare. BetterHelp is banned from disclosing any health information, which means they can't do any kind of targeted advertising, period, even just for, again, entrances into their website, even if outside of those bounds. So these court orders can have significant implications for various different strategies that a marketer would be doing for even awareness campaigns, as well as conversion. Also, some of these consent orders require annual disclosures of privacy controls and then biannual audits, and these can get very, very pricey. Some of these audits can be, a couple $1 million each round. We're talking about some of these orders to do them for 20 years. So there's a lot of operational overhead, even if we're not getting fined, just from the relief ordered by courts. And then most importantly, consumer expectations. I go back to that 49% statistic. 49% of people saying that they would switch from the preferred brand to the second choice brand if that second choice provided a better privacy experience. If we have violations, even if we're not getting called out by regulators, but if consumers are mistrustful of the practices, if we're not properly disclosing, or if we are hit with a violation, then consumers are obviously going to read about it, and there can be significant detriment to the brand and that relationship with our consumers moving forward, such that they'll leave. So what is our role as marketers? Kind of baseline here is be compliance conscious. That's what we can do. Consider these types of requirements. Now that we know what they are, consider them for all the activities that we're doing. So how do we do that? I'd like to simplify this by really just saying, let's ask some questions at a couple of stages in the process. And this is going to allow us to think through this. Are we respecting the privacy of our users, as well as to gather the information necessary that our compliance office is going to need when they're asking questions about, what are you doing? And when they're putting together privacy notices, when they're putting together plans for what an opt-out experience looks like. All of that can be, let's say 90% of it can be answered by just upfront doing a little bit of additional work here. So in the strategy and design phase for any kind of a marketing activity, we should ask a series of questions. First, what are we trying to achieve? What is our purpose? What is our goal with this particular initiative? In that, is it necessary to collect and use personal information? Are there alternatives? Could we use de-identified data? Could we use non-personal information in order to be able to reach that same goal? If still yes, what is the benefit to the consumer of this activity? What is the benefit to the business? What is the risk to the consumer? And then weigh those things together in order to be able to determine, do the benefits actually outweigh the risks? Now, I have in here that non-industry friend test. I think in the book, I call it the Grandma test. But what I like to do is any kind of activity that's dealing with, especially data, like targeted advertising, think about if I described how this targeting would work, what information is being used, how the segmentation is happening. If I describe that to a friend that is not in marketing, that is not in the industry, is it something that they would be comfortable with? Or would they be like, that seems, a little invasive. You shouldn't actually be doing that. If the answer is, yep, they'd be okay with, we're probably in the clear. If not, let's think about why and what alternatives are maybe there in order to be able to reduce that risk. The second kind of bit of this, so that's just, being privacy conscious. Is this okay? Are we comfortable doing it? Second is then for any activities within that initiative, we ask these 6 questions. So what is the activity that we're doing? What platforms are in use in order to be able to support that effort? What data are we collecting in order to support that effort? Is any of that information personal information? If so, what? Is any of that information sensitive data? If so, what? Where is that information sent? And then how is that information used? What is the outcome that results from us actually processing that information? If we can answer all of these questions, again, we're going to have 90% of what we need for a DPA. We're going to have 90% of what our compliance office needs in order for them to be able to do their thing as well. For this, have a little example. So paid search, something that probably most, if not all of us, are doing at our organizations. And just to walk through this to kind of bring it home and think through any current activities or current strategies or initiatives that you kind of have on the docket as well. So first, what are we trying to achieve with paid search? Well, we're trying to increase revenue. We're trying to improve our return on ad spend, doing things like bid optimization, creative landing page copy optimization. We're trying to increase conversions. Might be using a tactic like remarketing for that, and remarketing lists for search ads in the Google context. We're trying to increase brand awareness. Now, a note here on that last bit. If we're using tools within the advertising platform, so if I'm using tools within Google Ads, if I'm creating my audiences and I'm targeting based upon paid search context, keywords, based upon maybe demographic information that's available there, interest groups, things like that. That is Google's information. Google is the controller in that context. It's their obligation for the disclosure, for the opt-out and all of those things. So if I'm using just the tools and the data that's being provided to me by my provider, a lot of these obligations aren't going to kind of be applied for me. So that second question, what personal data is going to be necessary in order for me to be able to accomplish some of those outcomes and those goals that I mentioned? User identifiers, cookie device IDs, those are going to be there for sure. There might be some persistent user identifiers if I have login type of functionality on my website. I'm also going to have associated behavioral information, transactions, actions on my website or on my application, potentially some demographic data, campaign information. All of that which is associated with those identifiers or users is going to be necessary for me to be able to effectively target with some of the strategies I mentioned. What's the benefit in this scenario to the consumer? Personalized ad experience. We talked about earlier, that is the expectation. So that is a valid benefit to mention here. What is the benefit to the business? We can improve conversions. We can have more efficient ad spend. What are the risks here to the consumer? Thinking about even like in a remarketing context, annoyance, shown, bad ads, shown the same ads after they purchase something, but there's no financial impact. There's no offensive obtrusion for a reasonable person. In the worst case scenario, maybe someone, it's like on a shared computer, has an embarrassing advertisement or impossible reputational impact there. Fringe case scenario, but that risk is there. What are we doing to mitigate that type of a risk? Well, if we're transparent about, hey, we're going to collect your information in order to be able to better personalize ads for you, then that person, that worst case scenario, should be aware, and they have that opt-out ability, so long as we make that available. Now, in this scenario, do the benefits outweigh the risks? Again, I go back to that non-industry friend test. If I explained all these activities, in this case, I'm confident that they're going to say yes. So we passed that first kind of phase. Now, within paid search, I mentioned a number of different kind of strategies, tactics that might be used. Well, most kind of prescient one here is remarketing. Common tactic, definitely uses personal information. So we're going to use that in the example here. So for the activity within paid search, remarketing lists and search ads, again, with that Google kind of context, because that's where we're doing most of our paid search advertising. What platforms are in use in order to be able to support this effort? Well, we use Google Analytics in order to be able to understand behavior on our website, what content is being consumed, where are people kind of interacting. We then segment users and create audiences within Google Analytics and push that information to Google Ads for targeting and for the actual activation. And in some of these cases, we might be using an internal customer data platform in order to be able to kind of build our own audience lists from, say, subscribers to the website, segmented by industry, by interest, and then upload those lists again to Google Ads for more personalized targeting. So we have 3 core areas of platforms where some of that data is running through. What data is being collected and processed? Again, Google Analytics, we have our cookie IDs, device IDs, a Google ID, user IDs, associated behavior information, all that's necessary to segment and then target. In BigQuery, we'll have the emails, because those are those subscribed customer lists, and then some profiling based upon the GA behavioral data for that interest group segmentation. And then Google Ads, I'm going to have a Google ID, and I'm going to have what I'm uploading, which would be that assigned segment information for those users for that targeting. What of that is personal information? The identifiers, associated behavior information, associated profile segments. What of that is sensitive data? None of that is sensitive data. So we're in the clear there. Again, where is it sent? I'm sending that information to Google Analytics, Google Ads, to BigQuery, my Google Cloud platform environment. And then how is it being used? Ultimately, this is being used for targeted advertising, because that retargeting, remarketing, personalized advertising type of a use case that I'm using behavioral information from my website to power. So I know for sure I have some compliance obligations here, but I've gone through this exercise. And so I've mapped everything out more or less already. If we think back to those requirements that we have as marketers, we need to be able to respect consumer rights. Well, my compliance office, it's going to want to make sure all these things are addressed in the disclosures privacy policy. They have all the information now of what information is collected, how it's being used, where it's going, so that they can make sure that that's properly reflected. I need to be able to make sure I can access the information, correct inaccuracies, delete information. Well, now I know exactly what data is going to what platforms. So I can look to and develop a program for each of those platforms. How am I going to access it? How am I going to be able to delete it? And then for that opt-out, because I know the activities that are resulting in targeted advertising, I now know which activities and what data, which platforms do I need to limit processing or limit collection in order to be able to respect opt-outs for users. So I can design that architecture using that information that I just outlined. For my controller obligations, data minimization, I went through the exercise to be able to determine, can I accomplish the same outcome in the absence of personal information? And thinking through how would I potentially do that? Those technical and operational protections, again, I know where personal information sits, so I know where we need to have systems in place in order to be able to eliminate. Do not unlawfully discriminate. I can take care of that. Sensitive data, I'm going to be able to identify where it is, make sure consent is in place before that collection happens. Transparency disclosure we talked about, and then those data protection assessments, privacy assessments. I again know where and which activities for which I need to conduct those for, and those questions more or less are answering the same things I'm going to need there. So I have the documentation. I'm able to answer any questions that our privacy compliance office is able to put out there, and I can now know that I have what I need in order to be able to, again, respect those privacy rights of users. So that's kind of the exercise that I always recommend. A few helpful solutions here, just technical solutions to call out there. if we haven't been doing those exercises, sometimes it is necessary to do an audit of what platforms are loading, what data is being collected. We have a product, Tag Inspector, which can help give a lot of visibility into that across any websites. In order to be able to manage that disclosure as well as opt out, I recommend for organizations to always use a consent management platform. Just operationally makes that a whole lot easier. Two common ones that I like personally. OneTrust is probably the largest player in the market, especially if you're managing multiple sites. It is the best, quite frankly. They used to, I believe they maybe still do have a free tier if you have just a single website. Catch is another one. I've chatted with their founders a couple of times. Great guys. They also have wonderful content for privacy and compliance. They do have a free version if you are just operating a single website. That's another consent management platform. And then, as always, Infotrust on our blog, publishing all the time, educational resources. I'm working on a few more interactive resources to be able to run down a lot of this stuff. So check that out. And then obviously we have consulting services to be able to help out with all of these things. So kind of key takeaways here before we have a few minutes for Q&A. Consumer expectations for privacy. Just know that privacy is not just in the realm of compliance. Marketers, our goal is to be able to increase business outcomes by exceeding customer expectations. Customer expectations for privacy are there. Remember those foundational privacy requirements. Just keep in mind the basics. If you keep in mind the basics, if you're conscious of the basics, you're going to be able to be successful. And then, of course, be privacy conscious. We talked about those questions. We'll send this deck out afterwards, so you'll have them. Write that on just a little note on your desk. And then whenever you're thinking through, especially right now at the beginning of the year, thinking through different marketing initiatives and activities for the year, make sure that you're going through those questions and doing that type of an exercise. And I promise you, it's going to save you a lot of time and a lot of headache in the long run. Wonderful. Thank you all very much. I can open up the QA.
Yeah, thank you, Lucas. I do see a few questions in there, so we'll go ahead and start to read those out to you. So the first question I see, how do we distill this for small business marketers?
Yes, those questions that we went through towards the end. Even for those small businesses, again, you're not going to have the same compliance regulatory requirements because you might not be within those thresholds, but consumers are still going to be expecting the privacy rights to be followed. If nothing else, know all of the activities that you're doing and make sure that they're being properly disclosed and that you're just being transparent with users. That second question for, does this change with Google's discontinuation of cookies this year? None of these principles change. The regulatory requirements remain the same. The deprecation of third-party cookies in Chrome might change some of the marketing strategies or some of those different tactics that you're using in order to be able to accomplish, ultimate use cases and end goals. That doesn't mean that we shouldn't still be able to answer those questions with, some of those new technologies. So it's more the nature of how we're executing changes, which might change how we're answering some of those questions. But again, nothing changes from a compliance standpoint or from that base privacy requirement perspective.
Okay.
The question for digital properties, if that includes social properties or just websites and apps. Wonderful question. You do not own, I guess, those social properties, right? So, kind of. So no, you're not. These requirements, for you as the controller, would apply to the websites and apps. For social properties, if you're managing a Facebook page and whatnot, you're going to be using in-platform tools within the Facebook Business Manager. And Facebook is going to be the ones that are responsible for things like the consents and the usage of the data in using their tools, basically.
I would just add on to that question. The reason for that question is I had a ad vendor tell me that you can retarget within social properties, but not use your website data to retarget.
Yes, if you're using your website data, then you are retargeting on a separate property. If you're using, this is where it gets into a little bit of nuance for like that share definition, because there is a carve out for personalization based upon information collected on like your own property. In the context of also personalizing on your own property. So because all of that's happening within the Facebook ecosystem, it's a gray area because it is still targeted advertising, but it probably meets that requirement. That's something I've seen different organizations and different privacy teams go different ways on that. For some, they're saying, yep, that's fine. We're okay with it based upon their interpretation of kind of that clause. For others, they're saying no, because the intent here is still personalized advertising, for targeted advertising comes into some nuance. What you would want to do, review that with your privacy team just to see if they're comfortable with it. And you're going to be specifically looking at those sale and the share provisions as it relates to opt out.
Okay. I guess there's one more question. What is the fix for GA4? Is there a fix so you could still use GA4 on your website?
I'm assuming this is in relation to the healthcare, the health information.
Yeah, I mean, wherever GA4 is being restricted in terms of the ID, basically the IP address.
So there's a number of kind of areas globally. Where to start? We'll just cover in the US. For health related data, that one, there is no silver bullet. There is a way in which you can obfuscate some of the data that's being sent to GA. You can also use what's called a server-side tag management approach, server-side data distribution, which allows you to not send IP addresses to the Google servers. So you can also obfuscate some additional information there. So there is an argument that could be made that no identifiable information is being sent. That's not a simple fix. It's a pretty large architectural thing. And again, that's something that different legal groups are going different ways on. For general US kind of privacy considerations, respecting the opt-out provisions for things like advertising versus for using GA for something like first-party measurement. There are a couple of ways that you can do that. I have a, which I can send over, you can include with the deck. There is a GA4 kind of compliance guide that we have on our Tag Inspector website, put that together a couple of years ago. But that runs through a lot of those different options that you have in order to be able to address some of those challenges.
Okay, perfect. Yeah, I know we're running up against time, so we'll go ahead and close out here. I do want to round out this program today by introducing our Vice President of Programming, Edwin Acevedo, and he's going to talk about some of our upcoming programming, and he's going to tell you a little bit about the benefits of AMA membership. And thank you so much again, Lucas. It was a wonderful presentation. It's awesome.
Thank you.
All right. Hi. Thanks, Teresa. Appreciate your leading the discussion. And just wanted to say that there are some of the benefits to membership. Obviously, this is it's $169 a year, but really that's it's a bargain in my opinion. Some of the benefits of membership include professional development. Like happens when you are sitting in with experts like Lucas, or when you network with your peers, whether you're trying to improve in your current role or gain a competitive advantage. Those are things that you can get with a membership to AMA Nashville. The next event coming up is a networking mixer on January 23rd. It's in a couple of weeks. Location TBD. We have 2 online events, one on bilingual marketing and another on marketing Black hair, which is during Black History Month. We're having a panel discussion on this nearly $2 billion industry. Finally, our first thought leader luncheon is February 9th with Kevin Hartman, former director of analytics at Google. He's going to discuss the ROI of analytics as well as customer lifetime value and developing a mature analytics program. And so that's it for today. I know we're over time. Thank you to Lucas Long and Teresa. I'm Edwin Acevedo. Have a great rest of the week, everyone, and we'll see you next time.
Thanks, everyone.